in the name of personal injury law.
In previous episodes, we talked about how the 2019 auto no-fault amendments were affecting catastrophically injured auto accident survivors across the state of Michigan. Today we have Steve Sinas, a partner at the Sinas Dramus law firm, with his colleague Lauren Kizel to talk to us about a particular lawsuit that is going to affect these catastrophically injured survivors. Welcome back, Steve, and hello, Lauren.
Thanks for having us.
So my first question is, what is this lawsuit all about?
All right, so the 2019 amendments included some very significant changes that affect the rights of the most catastrophically injured people injured in car accidents. These changes include reducing the rates of reimbursement to their medical providers by maybe upwards to 45%. It also includes restrictions on who can provide care for them in the home and be paid for those services. So these are new rules that apply to people going forward, but our lawsuit, which is commonly known as the Andary Lawsuit, has to deal with the issue of whether these new rules apply to people who were injured prior to the effective date of these reforms, which happens to be June 11, 2019. So ultimately, the issue we're fighting for in our case is that the people who were injured prior to the effective date of the reforms were receiving their benefits under policies of insurance that were sold under the old rules, and therefore the premiums that the insurance companies charged were based on those old rules. And these people were relying upon their benefits being paid under the old rules. And because of that, we're arguing in our case that those contractual rights remain intact, and that what the legislature did in 2019 cannot take away those rights from these people. This is commonly referred to as the retroactivity argument, and it's ultimately about whether the legislature can pass a law that takes away the rights of these people that were a part of a contract and rights that they were relying upon in receiving their care. And so this is a huge issue. We filed a lawsuit that included other issues, but this issue, this retroactivity issue, is the prominent issue in that lawsuit. And it's now working its way through the court system, and we want the viewers to better understand that. So that's why I have my colleague Lauren here to help us understand that case.
So Lauren, can you tell us a little bit about what happened in the trial court of this case?
Sure. So our law firm filed our lawsuit a couple of months after the amendments were first passed. We filed our lawsuit in October of 2019 in the Ingham County Circuit Court. In lieu of filing an answer to the lawsuit, the defendants in the case filed what's called a motion to dismiss. So there's extensive briefing on these motions. Defendants filed briefs, we filed briefs. There were several interested parties who filed what are called amicus briefs on behalf of plaintiffs groups such as the Coalition Protecting Auto No Fault, the Brain Injury Association of Michigan, and the Michigan Brain Injury Provider Council all filed amicus briefs in the trial court. After reviewing all the briefs, the judge held what is called a hearing on the motion to dismiss and essentially agreed with the defendant's arguments and dismissed the case.
And then we brought an appeal to the Court of Appeals because we believe that, respectfully, that the trial court got it wrong in deciding that these new rules apply to people injured prior to the effective date of the law.
Correct.
Right. Okay. So can you tell us a little bit about what happened or what is happening in the Court of Appeals?
Yeah. So again, there was extensive briefing done in the Court of Appeals. All of those same amicus groups that I mentioned that filed briefs in the trial court also filed briefs in the Court of Appeals, as well as representatives Julie Brixey and the late Andrea Schroeder. They filed an amicus brief as well, which was very significant in this case. Essentially, they agreed with our argument, saying that they, as the legislators who voted on this bill, did not intend for the amendments to apply retroactively to people who were injured prior to when the amendments were enacted, which is very significant, highly unusual that the legislators would get involved in a case like this. Their amicus brief was signed on. It had a memo of support that was signed on by 73 other legislators who agreed, with the position that they were taking as well, saying that these amendments were not supposed to apply retroactively. So all of that briefing was all submitted to the Court of Appeals. We had to wait several months to get our oral argument date in the Court of Appeals, and that was actually recently just held on June 7th. It usually does take the Court of Appeals at least a couple of weeks to issue a decision, so that's kind of where we are waiting right now. We're just waiting for the Court of Appeals to issue their decision. We're hoping that it will happen anytime now. The oral argument was held by a panel of 3 judges, so the decision could be unanimous. All 3 judges could agree with either the plaintiff's argument or the defendant's argument, or it could be a 2-to-1 decision. But regardless of what happens, the losing party will likely be appealing to the Michigan Supreme Court.
Okay, so the case will not be over whenever the Court of Appeals does issue its decision. We are going to expect this to go on a little bit longer. Can you tell us about the Supreme Court process? What's the next step?
Sure. So, like I said, the losing party will likely be appealing to the Supreme Court. It's not a guarantee that the Supreme Court will take the case. You have to apply to appeal to the Supreme Court, and they have, they get to decide what cases they want to take. So if they do decide to take the case, there will be additional briefing done. Briefing done by both the parties, and amicus groups can file briefs again as well. And then there will likely be another oral argument heard by all of the justices on the Supreme Court. And then they'll likely issue a decision after that.
And one thing I wanted to make a point of is that this issue about these new rules and whether they apply to these people is a real issue for them and their ability to get the care they need. We've touched on that in other episodes, bringing people on who've been struggling to get the care they need when these new rules are applied. Another thing to keep in mind is that while the trial court disagreed with us, there have been several other trial courts across Michigan who have basically embraced the arguments that we're making in this case. So you have a split in trial courts across Michigan about how this issue of whether these new rules should apply to people who were injured prior to the reforms. And when you have that, you really need the courts to act to bring clarity and certainty to the law. And unfortunately, we're now into this appellate process that is going to take a couple more years to bring that clarity to people. And that's just an unfortunate reality of the situation that's created by these laws.
You make an excellent point, Steve, about how various courts around the state, trial courts around the state, are maybe resolving the same question in different ways. And I think that makes it even more significant, important for our Supreme Court to weigh in. Whatever the result is in the Court of Appeals, it's going to be one of those things that we need to have uniformity in interpreting the law, right? That's what the Supreme Court's there for, in my view.
Right, because Lauren and I have this experience almost every day now where we have to tell people when they call us that we don't know what the law is. Nobody knows what the law is when it comes to this issue.
And apparently not 76 legislators who signed it either. So that is pretty significant, Lauren, like you said.
Yeah.
Right. People think that the law is there and it's this clear-cut thing that you can tell them, what their rights are. And now we're just telling people day in, day out, well, your rights are hanging in the balance as the courts decide this major case.
And sadly, the appellate process is not fast. And I believe your firm did try to make the case go by more quickly, and that attempt was rejected. So you're just on a regular track, just like any other case. And then once it gets to the Supreme Court, I mean, I would predict we wouldn't have any kind of clarity until sometime like a year from now. What do you think?
Unfortunately, we agree.
Yeah.
Okay. Well, thank you so much for sharing this information with us today.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.